say that we have Sarah Galvin from Legal Services for the Elderly, Disabled, and Disadvantaged of Western New York, and we're very pleased that she was able to provide this webinar. She has essentially created this little department in her office specifically to focus on the liens that we all face when we're trying to work through loan modifications. So I'm very pleased that she was able and willing to put this together for us. We will be addressing questions, and she will be pausing on occasion to address those questions, so please put them into the questions box on your panel on the right-hand side. With that, Sarah, thank you so much.
Okay. Thank you, Becky, and thank you, Michelle. I'm going to start today just starting with going over what a lien is, going through the basics of why they matter when you're seeking a loan modification or another workout option for your clients. And then I'm going to go through a few different types of liens that most people are seeing when you're doing foreclosure defense work, and some tips and tricks for how to either get a subordination or have the lien removed so that it's no longer an obstacle for your clients. So to get started, a lien is essentially a claim of money against a property wherein the value of the property is used as security in repayment of a debt. It is a defect on the title and does need generally to be settled before the transfer of ownership of that property. Again, some of the types of liens that you'll likely see in foreclosure defense that are going to cause a problem are mortgages, such as second mortgages, home equity lines of credit, federal tax liens, Department of Social Services liens. I'm going to touch briefly on revitalization loans and judgment liens. Now, in order to figure out whether your client has other liens on the property other than the first mortgage, the first place you can look if your client has already been served with a summons and complaint is to review the list of defendants. There you can see if there are other defendants listed, such as the second mortgage. You might see the names of creditors that have judgment liens. That can at least give you an idea that you need to get started at looking at these with your client to figure out whether they're theirs, whether there's something that can be done about them. So that can be the first place you can look. I put on here that you should consider setting up online access to the public records in the counties that you practice in. For our project, we have a couple of counties now that have granted us free subscription to be able to view documents in the public records and print them as well. And it's very helpful because it does allow us to pull that information as soon as we open a file and to be able to give our clients a copy. The counties that we've talked to have been very supportive of doing this. So if you haven't already, I really encourage you to talk to the county clerk's office and see if something can be arranged so that you can have this access as well. Once you're able to take a look at the liens that are on the title report or in the public records, you'll want to show them to your client. Oftentimes, I have had clients with common names that the bank's attorney will essentially list every lien that they can pull on the summons and complaint. So this gives your client an opportunity to look through them. It gives you an opportunity to see if the address is matching up, if the middle initial is matching up. Oftentimes, it'll be quite different. And you can use that time at the beginning of the process of working with your client to let the bank's attorney know, the lender's attorney, that these are not necessarily your clients. Oftentimes, the lender or the servicer may ask that your client submit an ID affidavit. Some of you may have already seen this, but it essentially is an affidavit for your client to state that these are not their liens, and to describe why they know it's not theirs. Another reason you'd want to look at these with your client is sometimes the client has already filed a bankruptcy, and the underlying debt in the lien may have been discharged, but if a lien avoidance motion was not made while the bankruptcy case was open, the lien could still be on record as unsatisfied. I have come across in some of my cases that if the client has gone to a private bankruptcy attorney that charges an additional amount to bring that motion for lien avoidance, they may have opted not to spend the extra money, which is why those liens may still be on record. So that's another thing that you'd want to look at with your client. And just, obviously early discovery is best to avoid surprises after a trial modification is completed. So I'm sure some of us have had that situation where your client has gone through the whole process of applying, they finally got their trial modification, and then it comes back that they cannot proceed with a permanent modification because title is not clear. So having access to the public records, reviewing these things with your client will give you more time before you're surprised or kind of blindsided with the fact that they cannot proceed with a modification. So next I want to go through, should liens even affect whether your client gets a loan modification? So when I first started doing this work and we received requests for liens to be cleared, it seemed like something we just had to do, and in some cases you do. But I wanted to go through what really the law says about lien priority and whether or not any junior lien holders' rights are going to be prejudiced by the modification. So on this slide, I have some guidance listed on the bottom. The restatement third of property, mortgages section 7.3, gives some good information, and there's also a couple of cases here that have been used to determine whether a junior lien holder's rights are in fact prejudiced by the modification. So basically, the restatement of the law is saying that if a mortgage is modified and the junior lien holder's rights are prejudiced, then it could be a problem for the security interest of the junior lien holder, but only to the extent of any amounts added to the mortgage due to the modification. So specifically, some of the case law has pointed to the fact that modifications that would increase the interest rate on the mortgage in first priority could create prejudice to the junior lien holder. And that makes sense because you're looking at people having to pay more money over time on this first loan, which means that the junior lien would be paid even further down the line, would have to, wait even longer than what they had originally intended, looking at the original loan terms of the first mortgage. But as I put on here, most of the mortgage modifications that we are seeing are actually lowering the interest rate. They may extend the term and sometimes even defer some principal, but ultimately there have been arguments made that it improves the ability of the second lien holder to collect their debt. One, because you're avoiding foreclosure, and two, because your client is going to oftentimes be paying less money over time with the lower interest rate, even with the extended term. And again, even if it was determined that the modification does prejudice the junior lien holder, it would only result in the junior lien gaining priority over the additional amounts added because of the modification, not the entire loan itself. Specifically, the restatement of the law that is cited here states that very clearly that if the right is reserved in the mortgage document, the first mortgage, to modify the loan, and then in that point it doesn't even matter if the modification materially prejudiced the lien holder. So that's something to keep in mind as well. It might be worth looking at at the mortgage to see if there's anything in there that talks about modifications. So in a nutshell, a loan modification is prejudicial to a junior lien holder when that modification is not contemplated in the original lien holder, in the original mortgage, and the lien holder doesn't have notice of the possibility of such, and if there's some sort of prejudice that comes out of the loan modification. The last case that's listed on there is the case that will give you the information about how much would actually be junior to the junior liens in the event that the modification is in fact prejudicial to the junior lien holder. Now, even if the modification arguably is not prejudicial to the junior lien holders, you may still receive a request from the servicer that title become clear before proceeding with a permanent modification. There's a couple of reasons why this may happen. One is that the pooling and servicing agreement may generally just state that any risk be eliminated that jeopardizes the mortgage's priority position. And this is obviously a very general statement, but very conservative interpretations of language in the pooling and servicing agreement can lead servicers to flat out just require a subordination or clear title. Now, some of the language in the MHA handbook, HUD mortgagee letters, it's very similar. They're basically asking that the servicer take steps to ensure that the first lien position is in fact maintained. Now, taking steps is very general again. So if you believe that this is the reason, if you're receiving feedback that the pooling and servicing agreement requires that they have clear title, you should ask to see the language first of all, but also maybe working with the servicer to kind of get them to step a little bit back from that conservative interpretation, because there may not be any risk that needs to be eliminated. And another reason you may see that they are asking for a clear title is they may not be able to get their title company to offer lien priority insurance. So essentially, lien priority insurance would allow them to ensure that the lien position of the mortgage does not change due to the execution and recording of the loan modification. It can be issued on mortgages up to $1 million. And actually, HUD can reimburse the cost of the title and an endorsement under these insurance policies. So if they're unable to get this for some reason, they're going to come back and ask you to provide clear title, and that may be why, even if you believe that this modification is not prejudicial to junior lien holders and should not be an issue, you may still receive this feedback from the servicers. Does anyone have any questions at this point before I go into the next slides going through various types of liens?
It looks like there's no questions so far. Thank you, Sarah.
Okay. Well, then I will proceed. I would like to go through the 2MP program. Now, the 2MP program works in tandem with HAMP, which is the Making Homes Affordable Modification Program. And this is a program that's basically, if the first mortgage is modified under HAMP, servicers that are participating in the 2MP program must offer to modify or reduce the principal of the second mortgage, or give a notice with an explanation as to why that cannot be done. This program, the idea of it is a good one. However, less than 20 servicers are participating in the 2MP program. Personally, I haven't seen very many clients qualify under this program. There's a lot of guidance for it in the MHA handbook. It's in Chapter 5, and it goes through exactly what the servicers are required to do and what the eligibility criteria is. And you can also go on the HMP admin website to look at which servicers are actually participating in the 2MP program. But essentially, you shouldn't have to, this should be something that happens naturally as the loan is being modified. But if you think that your client has a second mortgage that should be eligible for this program and they're not receiving the letter and you haven't received anything about it, it is worth pointing out to the servicer that they need to look at doing this and talk to the second mortgage servicer as well. That there is a lot of information in the handbook, but again, I think the real flaw in the program is the fact that less than 20 servicers are participating, which really reduces the eligibility of many of our clients for this program. Just to go through some of the basic ones, you're looking at Bank of America, Bayview, City Mortgage, GMAC, JP Morgan Chase. A lot of the big servicers are the participants in these, but you'll need to match it up with what you're working with your client. Now, the other option that you have for a second mortgage, if the lender is requiring some kind of clear title or subordination, is to work with the servicer of the second mortgage to see if you can get a subordination agreement. On the next slide, I have taken the Fannie Mae Freddie Mac Uniform Subordination Agreement form, so you can take a look at exactly what information is needed. Now, some of the problems that I've faced with the subordinations is, one, working with the second mortgage servicer. They may have been out of the game for a while. Your client may not have been making payments. It may be difficult to find someone to work with you. The other problem is this is one option in trying to clear a lien that may require that you have some information about what the modified loan is going to look like. So for any of you that have had to fill out an application for requesting a subordination agreement, it often asks for information about what the loan is going to look like once it's modified. Sometimes it will look as if your client is trying to get a refinance, so some of the questions that they're going to ask on the application may not necessarily apply to your client's situation. And until your client has been approved, oftentimes you don't know what the terms of the modification are going to be, which makes it difficult to fill out the application for a subordination. So essentially, this may be something that you're trying to get between trial plan period and moving forward with the permanent modification. It may not be one of those options you can really start working on until you have that information from the first mortgage servicer. So here on the next page, you can see that they're looking for the date of the modification, what the modified principal amount is going to be. I've seen some of them even, more detailed, looking for interest rate, looking for, in addition to the modified principal amount, what the arrears were, and other things that you are going to have to work with both the first mortgage and the second mortgage that you're trying to get the subordination agreement with. The other difficulty that you can run into is that I have had cases where the second mortgage does issue a subordination agreement, but it doesn't comply with what the first mortgage servicer is looking for. So a good rule of thumb is to try to get exactly what it is that the first mortgage needs that subordination agreement to state, so that you don't go through this whole process only to receive a subordination agreement that you really can't use or that isn't helpful. And then trying to get it modified after the fact can be more difficult than sort of setting out while you're working with the second mortgage servicer of what you need. But again, this is the uniform form that's online for Freddie and Fannie. It gives a good idea of what the basic language is going to be for a subordination agreement. And again, this process can be long. It's going to require working with both the first and second mortgage servicers. If you are working on a foreclosure case that's currently in settlement conference or in some other stage of litigation, it can be helpful to get permission from opposing counsel to be able to work with the first mortgage servicer just for this purpose, because sometimes going through opposing counsel can be a little bit difficult when it can be infinitely easier to work with someone at the bank who's working directly on this. And again, if the borrower hasn't been making payments on their second mortgage, oftentimes the servicer is going to want them to start making payments. Essentially, they feel if your client is asking for them to do something, they're going to want payments to resume. That's something you'll have to talk about with your client in terms of affordability. That may not be something that was factored into their budget. Hopefully they can make that work. All right. Another way that you can work with second mortgages, and this falls into the category of second mortgages that your client may not have been making payments on, is bringing an action to discharge the mortgage of record based on a statute of limitations. So CPLR 213-4 basically allows for a mortgage to be discharged if the statute of limitations have run. Now, the case that I have listed on here, the second one under additional guidance, this case determined when the statute of limitations should begin to run. So in this case, what they wanted to look at is whether it should be from the time of acceleration of the loan or from the date of the last payment. The statute of limitations in mortgage cases is 6 years. So in this particular case, they were looking at a mortgage that had been accelerated but no movement on the foreclosure for 6 years. And that is when you could determine a statute of limitations has run. However, if the loan has not been accelerated, your client just hasn't made payments, it's going to run from the date of the last payment. Now, a lot of your clients may not remember when they stopped paying that second mortgage or that home equity line of credit. So what we usually ask our clients to do is to get a credit report, and you can see on that credit report in most cases where the last payment was made. I have had people say, yeah, it's been 6 years, and then I take a look at the credit report, and it's pretty clear that it was only 2 years ago that they stopped making payments. So for your own preservation before you go through the process of trying to bring an action to discharge this mortgage, it's a good idea to get a copy of the client's credit report, especially if they don't have any statements or anything else that can help you try to determine what stage this mortgage is at. Now, when you bring an action to discharge the mortgage under RPAPL 1501, one thing is you are going to have to require your client, unless they are eligible for a fee waiver, to cover the cost of the filing fees. So that's something you'll want to talk to them about right away before you file this. And you are going to want to put in your pleadings exactly when they stopped paying. And sometimes we have had cases where we do this and the second mortgage doesn't respond at all, and it's easily granted. But you'll want to make sure that you give all of the pertinent information in your complaint, stating that you are bringing it under this particular section of RPAPL, that your client is the owner in fee simple of the property. You're going to want to give them the exact date that the mortgage is recorded, and that the mortgage is adverse to the plaintiff's interest. In here, most of the time, you'll want to state, too, that you've made reasonable efforts to get a discharge of the mortgage. But, for example, if you have tried to contact the second mortgage holder to get a subordination, but you're not getting anywhere, they can't find the loan, sometimes that can be helpful to add in your complaint as well. And you're basically asking the court to discharge the mortgage of record that's referenced in the complaint. You'll want them to declare that the remaining balance of the debt, if any, is satisfied, and that the defendant in this case, the second mortgage, be prohibited from asserting any claim by virtue of the mortgage or mortgage debt discharged herein. So does anyone have any questions so far about the liens that we've gone through?
Yep, so we've got a couple of questions.
Sure.
The first one is, let's see, is it the timing of the lien being placed alone what establishes the junior versus senior lien holders?
So do you mean when it was, I mean, essentially it's when it was recorded. Is that kind of, I think, what they're asking for?
I believe so, yes.
Yeah, so you're looking at when these mortgages are recorded, mortgage or judgment. So generally, when your client obtained their mortgage, it should have been with clear title. So any judgments, any second mortgages, generally are going to be filed after the mortgage has. I'm not sure if that answers the question.
I think so, but if not, hopefully they'll post something and follow up.
Okay, great.
So does the plaintiff's attorney ever prepare the subordination agreement?
Sometimes we have received copies of what they need. As I mentioned before, I usually try to talk to someone from either the opposing counsel for the first mortgage, or if I can talk to someone at the servicer's office that deals with subordinations to see if they have one that's already a model that they use. I've received them from both, sometimes from the second mortgage, sometimes from the first, and but really just clarifying exactly what they need that subordination agreement to state is going to be helpful, because if you get the model one from the second mortgage and you see it's not matching, you can try to clear that up before you go through the whole process.
Let's see. Have you ever found second lien holders may charge a fee for the actual execution of the subordination, not for the payment for a defaulted second?
I have not actually, yes, I take that back. I did have, I believe it was Wells Fargo had asked that a check be sent in with the application for the subordination agreement. With that one, I actually called because I believe that's set up if your client is receiving a refinance. A lot of these forms are sort of defaulted for that, which, as I mentioned before, makes it difficult to both fill out the form and you know, the request for money, I think, is meant because you're trying to get a refinance. In the case when I had that come up, I just talked to Wells Fargo, and they said that we didn't have to pay, given that the client was seeking a subordination for a loan modification, because of a loan modification. So that would be my suggestion, is that you just explain to them that it's a different circumstance than what the form may be anticipating you doing this for.
Okay, and then a follow-up for that is it the borrower's responsibility to secure the subordination agreement, or have you found that the banks will contact the second to get this done, since the borrowers don't always know that what the modified terms are until the actual document is issued?
I've seen on occasion the first mortgage reach out to the second, especially in more difficult cases, or sometimes in cases where it's the same servicer, or at least something similar. I know, you know, there are different subsects of some of the bigger banks, but sometimes they will. Right now I'm working on one where we're kind of just sitting back, and the first and second are going back and forth about what exactly is needed, and we're just monitoring that to make sure it happens. It's nice when they're proactive about it, but oftentimes when we're doing these, we're doing the bulk of the heavy lifting and getting this done.
And then two more questions for now. Are there any types of liens that can jump over the mortgage lien? And I'm assuming that means in the form of a foreclosure. So if you have a first lien mortgage and you don't have anything else filed first, is there something that would take priority over that mortgage?
Or maybe they're thinking of IRS.
I'm assuming, but I'm assuming that.
Okay. Yeah. So you know, in situations, and I'm going to be talking about federal tax liens next. You know, often they're going to state that they have priority, even if the mortgage has already been recorded. So in that case, yes, and I have tried to make the argument that why do we need a subordination or a withdrawal of a federal tax lien if they're going to be paid first anyway, but I haven't really gotten too far with that, so some of the things I'm going to talk about next have been more successful for us in getting past federal tax liens. But I hope that answers the question. If not, please follow up.
Okay. And I think that part of this you'll cover, but let me put the question out there and you can say you'll address it later. How would a discharge of the note under the 6-year statute of limitation remove the lien created by the mortgage?
If they're referring to bankruptcy, I am going to touch on that later. If they're referring to the action under RPAPL, with that, you're asking them to discharge the lien, to remove the lien in that action. That's really the basis of that. If you're mentioning bankruptcy, I will be talking about that a little bit later on. So hopefully that's.
So why don't, hopefully if they have a question after the bankruptcy section, they'll follow up.
Right.
And then, yes, the follow-up was yes, the IRS. So I think that answers that.
Okay. Well, if that's all the questions for now, I'll move on to the federal tax liens.
There's another one, but I think we can probably wait. It's more of, I think you should go on, yes.
Okay. All right, so with federal tax liens, as I mentioned before, oftentimes, even though they do state that they would be paid first, there are two ways really that are useful tools to try to either subordinate a federal tax lien or to actually fully withdraw the tax lien. Now I'm going to go through the subordination section of this first, but personally I find this to be more difficult than the withdrawal. So IRS Publication 784 gives you instructions on how to apply for the Certificate of Subordination of a federal tax lien. Now this is somewhat similar to a mortgage subordination process in that you're going to have to provide that same kind of information about the current loan amount, the amount of the new financing. They often want appraisal information, title information. You're really looking at supplying a lot of information here. Now, that is going to all be put on Form 14134, and I do have that here in the slide. And essentially, you're going to put all of the information that they need, but you also have to select what the basis for subordination is. And you have two options. One is that it would require your client to pay something. There's a full calculation, an example of calculation in IRS Publication 784. But essentially what they're wanting to have your client pay is the United States interest, which is the equity that you get from your refinance loan. So I think the idea here is that if they are being prejudiced at all, they want that portion that's prejudicial to be paid to them of the lien. To me, this is a very complicated thing to discern because you really need to know, one, the fair market value of the property, what the modification is going to be, if there's any closing costs, which is usually more applicable to a refinance, but with a modification, it could be the foreclosure costs in here, and they require you to basically figure out a few ratios and come up with a number that your client would have to pay. So that's one. And for clients that are struggling and are trying to be in a position where they can afford making mortgage payments again, this really isn't going to be an ideal process for them. The other way is that you can assert that the subordination is going to basically improve the IRS's claim, their lien, and make collection easier for them. So, for instance, if a refinance or a modification is being made to a lower interest rate, and this lower interest rate would allow a larger monthly repayment on the tax liability, or arguably if if, as we mentioned before, if it improves their position just by virtue of the fact that your client's going to be paying less over time. But they're really, this is something that's really going to be something the IRS is going to have to determine. So you may not know whether that's going to be an option for your client. So while this is one tool that you can look at, I really have had more success with the next option, and that is withdrawal. So with this, you're looking at removing the public notice, so the lien that's filed in the public records with the obligation still remaining to repay the tax debt. For that, you're going to have to complete IRS Form 12277, and I have that here. And this requires a few steps that your client is going to have to take. So they need to enter into, or if they're already in a repayment plan, convert it to a direct debit installment agreement. So when we've done these for clients in the past, we've been able to get fairly reasonable payment plans. And once 3 consecutive direct debit payments are made, you can basically have put in this form so that they can remove the lien. The tax liability cannot be more than $25,000. There is an option to pay down, so if your client owes a little bit more and they do have the means to pay down their total tax liability, that is an option. The plan also must pay the obligation in full in 60 months. So when we're looking at affordability, that's something that you can determine with your client before they even start to agree to these direct debit installment agreements. And they also cannot have a default on previous or current arrangements. Hopefully this wouldn't disqualify many clients, but sometimes it can be an issue. As far as working with the IRS, we will sometimes work on behalf of our clients in very limited situations. I just wanted to give everyone a few places to look if you're a little bit wary of working with the IRS, if you're not a tax professional. The Treasury Department Circular number 230 gives some guidance on who can practice before the IRS, and there are some limited exceptions here under section 10.3, 10.37, and 10.35. And this is just going to give you some guidance, as to whether you want to just tell your client that this option exists or whether you want to be more active in helping them do this and working with the IRS directly. I know some offices are more conservative about whether or not they're going to do a lot with working with the IRS. So that can give you some guidance, those sections, as to how much you want to do. Here, I just wanted to touch briefly on neighborhood revitalization loans. I know these come in a lot of different forms depending on where you are, but I have had situations where we've been told that there's a neighborhood revitalization loan that is clouding title. These are loans that are offered through a local entity to cover repairs. Sometimes they have small monthly payments, sometimes there's no payments, but many of them have a provision that after 10 years or a certain number of years of inhabiting the property, the loan is basically forgiven or is no longer owing. I've had several clients that have surpassed their time, and they don't realize that they're actually responsible for recording the satisfaction. And sometimes it's just a matter of either having them track it down that they may just have sitting in their house and it just needs to be filed, or seeing if you can obtain another one from whatever entity has provided the loan. But best case scenario, that can be something that can be done. You can also talk to the local entity if they haven't reached that period about whether they can give some sort of statement on subordination. But those are some options there. Now I'm going to talk a little bit about Department of Social Services liens. Empire Justice Center actually just came out with a really great report called Don't Lean on Me. how New York's public assistant mortgages undermine homeownership and financial stability. And there's also a toolkit. So if you haven't already seen this, if you are trying to work through overcoming Department of Social Services liens that are causing a problem for your client, I really encourage you to take a look at this. I'm going to go through some of what they talk about, but it's very comprehensive. The toolkit is really helpful. So essentially, the Department of Social Services can put a lien on a home for payment of certain types of public assistance received. I've had several clients come to us that claim they had no idea that they were actually signing what's essentially a mortgage because they're receiving public assistance. And one thing that is brought up in this report, which has proven to be a problem with working with these liens, is unlike others, you don't have a true idea of how much is owed. So generally, there's not a regular accounting given to your client, the homeowner, of how much is owed, how much is accruing, because as your client continues to receive benefits or continue to receive benefits, it's accruing a higher balance, but you don't exactly know what that is. Many of these I've seen, at least in our area, are stated to be $1, but with the ongoing accruing, so you can't tell just by looking at them. And then there's also, there hasn't really been a uniform process to subordinating these existing liens. We've tried in our county to develop a relationship with the county attorney to see if there's anything that can be done, but there really hasn't been a lot of welcoming with open arms to trying to figure out a solution to this. And I know in some counties it may be easier than others to subordinate a DSS lien, but really this is a big problem. And part of what's in the report as well is a list of, by county, of which counties have a lot of these mortgages, which can give you an idea of where you're practicing, how much this is really going to create a problem for your clients. So in terms of trying to work through these, again, if you can work with the county attorney and if you have a good relationship, that's great. But you're really going to want to request a payoff amount and a breakdown of any charges, any amounts accrued. One reason is that some categories of assistance are actually exempt from recovery under the mortgage that they've signed. So this can include HEAP, SNAP, EAA, which is essentially emergency assistance to people over 65 and people that are disabled, and then for child care assistance. And again, you'll want to make sure that this hasn't been included in the amount that they're trying to claim under the mortgage. Now, if you do see that there is a problem with the amount that's being charged, in the toolkit that's online, there is an order to show cause and petition. There's a fillable form. It's a great resource if there is a problem with the amounts that are being charged to your client. But a lot of this right now is really relying on working with the county attorneys. And I know a lot of us have had problems, and it's really just being persistent. And I know that in the materials that are on Empire Justice's website, there's information about what we should be asking for in terms of making this not be something that DSS can do anymore. So what they're looking for is repealing SSL Section 106, which is the law that allows them to do this. Now going back to the statute of limitations defense under our PAPL, it has been determined in several cases that the statute of limitations does apply to these DSS liens as well. They have tried to make arguments that it shouldn't apply, but there's pretty clear case law on that. So if you're looking at a DSS lien that you believe may have that statute of limitations defense, that may be something that you want to pursue if you're not having any luck with a county attorney being agreeable to subordinate. I'm going to take a little pause here. Are there any questions before I move on to judgment liens?
So there's one question. What is a super lien, and does it apply in New York State?
I'm sorry, can you repeat the question?
Sure. Sorry. What is a super lien?
I'm actually not familiar with what they may be referring to.
Okay. So hopefully they'll clarify what that is.
Yeah, and if at the end I'm giving my contact information, so if it's something that I can look into after, they can certainly email me.
Okay. I will. Let me tell you what the question is about. It's a very specific. It's a case example and a question, and it has to do with the ID affidavit. Do you want to address that now or later?
I can maybe address it later, because let's see, at the end I should have some time.
Okay, great.
And then if not, if it's very detailed, it might be best to be emailed.
Okay, so then that's it for now.
Okay, so I'm going to move on to general judgment liens. These are the liens that you're going to see that often arise from credit card debts, deficiencies from repossessions, such as car repossessions, and other consumer issues. One thing that we like to look at with these is whether there's any basis for trying to vacate a default judgment. So there's a lot of material out there right now that discusses the problems with basically service, with people that are being sued for a credit card debt, some other debt, instances of sewer service, problems with people maybe not receiving their summons and complaint. So I wanted to just go through the criteria for bringing in order to show cause to vacate a default judgment. If that's something that you've identified your client should qualify for. Now, there must be an excusable default, so a reasonable excuse for missing the original court date, and a meritorious defense that can be raised. Now, this needs to be brought within 1 year of receiving a copy of the judgment. So I'm working on one right now where the judgment was awarded back in, I believe, 2011, but client maintains she just got a copy of it now. So, you can look at seeing whether you're still within that 1 year by talking to your client and having them bring all the paperwork in. The other option that you have is generally lack of personal jurisdiction. So these are the cases where there may be improper service. Again, having access to the public records can be really helpful because you may be able to see any affidavits of service that have been filed and take a look to see whether there are any major deficiencies with that. And there's no time limit to bring in order to show cause to vacate a default judgment for the lack of personal jurisdiction option. So it's a really good idea to, I think, look at this. One, because if the lien is causing problems for your client with obtaining a loan modification, it's one way to get over that hurdle. But this is a real problem in our community, and it's important, I think, to challenge these when we see that there are clear violations of law. If it's a valid judgment and your client recognizes the debt, they recognize that they were served, you can move towards trying to resolve it. One option, again, is seeing if they will subordinate. I have really never talked to a creditor, a debt collector that's handling the judgment that didn't want a payment agreement before agreeing to subordinate. And again, sometimes if your client doesn't have the means to do this, that can be a difficult option for them to look at. Similarly, offering to settle the debt for less than what is owed can be a good option if your client has the funds, but generally they're going to need to have a lump sum available. I have been able to negotiate over a few months, but really with a settlement for less than what is owed, they're wanting to get paid fairly quickly. So these two options, you're really going to have to prepare your client for the possibility and the very likely possibility that they're going to have to come up with some funds to pay these. And again, you really just want to make sure that they're paying something that's actually a valid judgment before making an agreement. So if you do decide to reach some sort of payment agreement or some sort of settlement, I just have a few tips here on, any agreement really needs to be in writing. It needs to include the information on the original debt, who the current debt collector is, the specific terms and due dates of payments, and very important to have a statement that the agreed upon payments will satisfy the debt in full. You don't want to get your client into a situation where they're having just as many problems with a payment arrangement as they are with their mortgage. So just good rules of thumb with trying to work out something with a judgment lien. Now moving on to options under bankruptcy, I just want to state that I'm not a bankruptcy attorney, so many of these cases that involve needing a bankruptcy or giving bankruptcy advice, we do refer to one of the bankruptcy attorneys in our group, but I'm just going to briefly go over it here. So lien stripping is the process of eliminating junior liens in a Chapter 13 bankruptcy. So if the first mortgage is already more than the fair market value of the home, under this process, the second mortgage could be considered unsecured. So like other unsecured debts, it could be paid at a lesser percentage over the 60-month period, and the lien itself could be stripped from the property, which could help you get over that hurdle of needing some kind of subordination. Lien avoidance under Chapter 7 would be basically looking at a lien that resulted from a money judgment issued by a court. So going back to what we just discussed, judgment liens, if the underlying debt is discharged in the bankruptcy, as I mentioned before, if a specific motion isn't made, that lien may still remain, but it's important to look and see if that's something that can be reopened and made if your client actually has had that discharge given to them in a Chapter 7. And you can also claim an exemption in some of the equity in the property. And that's pretty much all. I just wanted to kind of give you some basics here. I don't want to go too much into bankruptcy because I'm probably not the most qualified person to do that, but just so that you're aware that there are these two options under bankruptcy. And now I can take more questions if people have additional questions.
So there was a follow-up about that super liens question.
Okay.
And they said that they believe super liens have to do with condo association or homeowner association fees.
Ah, okay. So what is the question about the super lien? I'm sorry, can you repeat that?
Do we have them in New York State? What are they, and do we have them in New York State?
I have dealt with homeowners association liens. I haven't had them come up as a problem, so I'm sorry I don't think I'll be able to give the best information on that. But, I can certainly follow up if the person wants to send me an email, and maybe I can be more helpful if I have more specifics.
Okay. All right, so we have a specific question about lien avoidance. I've handled lien avoidance in bankruptcy many times, and she offers 2 points. You can still get a lien avoided in a Chapter 7 if there is no equity, so the house is underwater, and you can reopen a case, although there is a fee, to avoid a lien if the attorney didn't do it, I'm assuming, in the original bankruptcy.
Right. Yeah, we've looked at whether we want to start doing that for people or not, because oftentimes, if the client can't afford the fee, you're kind of stuck. But yes, yeah, that's helpful to state.
And then let's see, the last question I have at the moment is that ID affidavit question.
Okay.
Do you have samples of it is the first part of the question.
Mm-hmm.
So maybe if you can send that along to me or Michelle, Sarah, we can send that out to the folks that have attended today.
Sure, yeah, and oftentimes the service will provide you one as well, but I can send what I have.
Okay, perfect. And then we have an example. So let me see if I can try to summarize this. They have a husband, wife, well, they have a client, the wife, The husband and wife bought the house together. The husband died, and now the wife is in need of a loan modification. Now, husband was, let's say, Mr. Jones Sr., the dad, and the son is the junior, and they have the same first name. Right? Following along?
Yep.
So the son has lots and lots of liens and somehow became attached to the mortgage, and the mom, and he has no intention of doing anything about those liens, it sounds like. And now the mom is trying to figure out how to get a loan modification with all of these liens that don't belong to her dead husband, but rather her son. And so now, here's the very specific facts of this one. The mom finds that she has something like 15 liens on the property, totaling about $63,000. Son has no intention of having these liens taken off the property. So, would the ID affidavit be the proper course to follow here?
Yes, assuming that the son, so one, I assume the son is not also on the deed to the home. And then there could be two situations. I actually just had a case that was very similar. Father was being sued for his son's death. They have the same name but just different middle initial. And in that situation, I guess there's two things. One, if the client, if the husband, so the senior, if he was the one that was actually sued in court, it may be worth looking to see if you want to try to vacate the judgment, if it's a judgment.
The son is not on the deed, so this
okay.
There's a problem with the essentially like a credit reporting type of dispute, right? But
if
when they're doing the search, they're pulling the son's liens rather than...
Right. I mean, if it's a credit reporting issue or if it's truly linked to the deceased husband, then you may have, you may want to pursue some other things to try to vacate the liens. But the ID affidavit, if you're just dealing with the servicer, if the servicer has come to you and said these liens are a problem, the ID affidavit should be sufficient. I think you may run into some complications because the person who would normally sign the ID affidavit is deceased. So you may want to provide some additional information. So, for instance, sometimes pulling the liens can show that there's a different middle initial. So if you have any type of identification for the deceased husband, that can also be provided to show that there's actually a different name between who's on the deed and who's on these judgments or liens. That can be helpful. But if you're just trying to deal with the servicer, yes, the ID affidavit, but you're going to have to overcome a few more hurdles just because there's not the person to affirm.
Right. Okay, so then the last question, it looks like, is there anything that can be done when you're seeking a deed in lieu of foreclosure and there are liens on the property other than going through the lien stripping in a bankruptcy?
Yeah, I mean, that's pretty much where we've been stuck with, what we've been stuck with. Deed in lieu and short sale are kind of exceptions to what I was talking to at the beginning, with whether a lien should matter, because, you're really looking at true title issues. So really that's been where we've been stuck with deed in lieu and short sales. I mean, unless you can work out some sort of arrangement with the junior lien holders, where they're willing to get rid of their lien, which is unlikely, you're kind of stuck. I mean, or you can try for the RPAPL, if there's a statute of limitations issue with a mortgage, you could try that as well.
At this point, I don't see any other questions. So I would say that if there were a couple of open-ended questions or open questions that we haven't quite fully answered, if you would like to call Sarah, she has already volunteered, so I'm not volunteering her officially. And feel free to contact her. Sarah, I really appreciate your time with this today. I know that we all face these issues much more on a regular basis, so this is very helpful. I do want to announce the next webinar. I'm not certain yet, unfortunately, as to the date, so stay tuned, but it may be on the June 25th. But it's going to be the death of the mortgagor, problems with the foreclosure defense when the owner is deceased. So hopefully that will be useful and helpful for folks. And oh yes, and there is a CLE code, and it's 1771. It's also, if you missed that, it's in the chat box. Michelle Peterson has sent that out to everybody. I think that's it. Sarah, thank you so much.
Okay, thank you.
Michelle, do you have anything you would like to add?
No, we're all set.
All right, thanks everybody. Have a great day.